So we have 19 pages of Cardi B's lawyers responding. It's Wednesday, October 15th, and today we've got to talk more about these lawyers. I haven't seen anything quite like this. It's not that we haven't seen lawyers that haven't been our favorite. We've seen that. It's the manipulation and the gaslighting and the childish, unprofessional tactics of, I know you are, but what am I? I know you are, but what am I? We haven't seen anything quite like that. The OSC response that we went over yesterday, defense counsel, Cardi B's counsel is asking for sanctions, up to $25,000 in sanctions, plus attorney's fees, plus contempt. And the response was, Your Honor, I only saw this today, the day after it was filed. It was ridiculous. But the fight in the hallway case, I have updates on. So we're going to do that too. This is from October 7th from Mr. Anderson, Peter Anderson. Memorandum of Points and Authorities. Cardi B timely filed her application for an order to show cause why plaintiff's counsel, Ron, should not be held in contempt and sanctioned for violating the court orders and for his trial misconduct. Ron's knee-jerk reaction to that filing was to try to punish defense counsel by late filing his own application despite lacking a legal or factual basis for the issuance of an OSC. In short, Ron and his application resort to fabrication and falsehoods. Excuse me, Your Honor, fucking lies. But he does demonstrate why defense counsel has limited all communications with him to writing and took pains never to be alone with him. Footnote 1. In addition to Mr. Ron's misconduct that triggered defense counsel's insistence on written communications, his reputation precedes him. For example, in at least one case, he was sanctioned for $22,933 for multiple instances of misconduct and also triggered a mistrial by allegedly striking defense counsel. And they cited the ABA Journal article that we've read and the Law 360 article Geragos judge told of schoolyard-style attorney altercation. Kindly put, Ron has a tenuous grasp on the truth and professional ethics. His application is a ruse and should be denied. As an initial point, Ron's admission that he filed his application only because Cardi B filed hers confirms his application is just a ploy. If there were meat to his application, whether to file it would not depend on whether Cardi B filed her application. Further, Ron points to no statements by Cardi B or her counsel that she decided not to apply for an order to show cause directed to him. Instead, he first argues that Cardi B's statements to the press after the jury returned its verdict, quote, made it appear that the parties would be walking their separate ways. He was not there, and as a result, his assertion is hearsay. Further, he omits her actual statement because Cardi B referred only to not pursuing claims against Miss Ellis and nowhere mentioned Ron.
This time around, I'm going to be nice. The next person to try to do a frivolous lawsuit against me, I'm going to countersue and I'm going to make you pay.
He next argues that because his September 3rd letter to defense counsel went unanswered, he assumed, quote, that everything was fine and that the parties would be moving on. But he fails to disclose to the court that his September 3rd letter relayed a settlement proposal, and he ended that letter by directing defense counsel to, quote, respond within 24 hours if your client wants to settle this case. Girl, no, you didn't. It goes on to say it is patently absurd for Ron to claim that not responding to his letter asking for a response, quote, if your client wants to settle, meant to him that everything was fine and that the parties would be moving on. The audacity. Cardi B wins. There's no liability to her. The jury came back in 17 seconds. That's hyperbole, but the jury came back with a swiftness that indicates that they didn't take long or need long to discuss the issues and that figuring out the verdict forms and the jury instructions probably took most of it. And the next day, the day after she wins, he reaches out and emails her attorney, would you like to settle this case with us now? Because what? You're gonna appeal? Would you like to settle? Fuck no. What attorney would settle this case after they won? On the off chance that the appellate court might do something wonky. Because if the appellate court does something wonky, they might choose to appeal it higher. Ron does not rebut Cardi B's application for an OSC directed to him. Cardi B's application meticulously establishes 25 violations by Ron of the court's orders and the rules of professional responsibility and accepted trial conduct. Make it 26. Put that declaration in there. Make it 26. In the meantime, his application includes half-hearted shots at Cardi B's application, but none of them land. Ron dismisses her application as quote-unquote frivolous, but her application is supported by the transcript and established law, proving his violations of the court's orders and his trial misconduct. He misquotes her application as stating he is a quote-unquote seasoned trial lawyer and denies that supposed assertion. Yet he does not dispute that he was admitted to practice over 20 years ago. And proving Cardi B's point that he is no novice, he volunteers that he has tried approximately 10 different cases and served as co-counsel in several others. Of course, even a novice lawyer is able to comply with judges' orders in limine and as to closing argument. The fact that Mr. Ron is no novice, yet still repeatedly violated those orders, confirms that Cardi B's application for an OSC directed at Ron should be granted. Yeah, it should. It's like you're doing this shit intentionally and don't give a fuck. That's how it appears. Declaration of Mr. Anderson, adult, licensed attorney, represents Cardi B. In his application, Ron states that I supposedly, quote, unlawfully made contact and assaulted and battered him. Those accusations also are false. Indeed, the only time in my life that he and I have ever been at the same place at the same time was in courtroom T during the July 30th final status conference and during trial. Ron's assertions that he was assaulted and battered in front of those witnesses and the sheriff's deputies is beyond absurd. As for Dr. Finke, Dr. Finke testified he arrived in the hallway outside Department T and was talking to members of the defense team. Shortly after Dr. Finke arrived, Ron walked quickly towards me and others, including Dr. Finke, and said loudly he wanted to talk to Dr. Finke. I asked Dr. Finke if he wanted to speak to Ron, and Dr. Finke said he did not. So I asked Ron to please leave him alone, and then when Ron insisted on talking to Dr. Finke, the sheriff's deputies stationed in the hallway approached and told Ron to step away and leave him alone. At no point was there any physical contact or yelling, and if there had been, it would have been directly in front of the sheriff's deputies. I never saw Ron outside the courthouse, and when I left the courthouse, there were multiple sheriff's deputies in the hallway and outside the entrance to the courthouse. Signed under penalty of perjury. Exhibit number 1. This is from September 2nd, reporter's transcript. Ms. Moore, Your Honor, may I please say one thing? The court, go ahead. Ms. Moore, I just want to note that you advised Mr. Rosen that if he were to argue to the jury that Cardi said the photograph was taken on February 25th, that would be a knowing violation of professional rules. And that's exactly what he did. The court, okay, well, Ron, I want to respond. The court, I don't want to do it now. Ron, well, I have to say something about it. The court, you don't. I've said we'll discuss whether or not we want to set an OSC and we will address it then. Mr. Anderson, thank you, Your Honor. Ron, okay. Are we surprised that we get through Cardi B's attorney's response and the response is, excuse me, Your Honor, everything that guy said is bullshit. We learn a few interesting things in the reply, though. We learn that the email that Ron sent to Cardi B's attorney, Mr. Anderson, was not regarding the OSC, it seems, but it was an offer for settlement, right? So September 2nd, Cardi B gets a favorable jury verdict. September 3rd, Ron emails counsel saying, if your client wants to settle, respond to us in the next 24 hours. Girl, settle what? He asked to settle it on September 3rd. So, of course, Mr. Anderson said, Your Honor, this offer of settlement had absolutely nothing to do with whether or not we would be moving forward with the OSC. He also points out that where Ron said that there was a assault and battery, those are the words that he used, in the hallway while Dr. Finke was there, he said, no, Your Honor. In Mr. Anderson's declaration, he said, we were in the hallway. Ron came over to us and said that he wanted to talk to Dr. Finke. I said to Dr. Finke, do you want to talk to that guy? Dr. Finke said, no. And so I said, he doesn't want to talk to you. And then Ron persisted about wanting to talk to Dr. Finke. And then the sheriffs said, hey, step away. That's not at all what Ron said happened in his sworn affidavit. So do we have count number 26 of Attorney Rosen misrepresenting things to the court in a sworn declaration? I have questions. Oh. And on page 1, Cardi B's attorneys dropped a footnote, including the articles that we have read about the hallway kerfuffle with Attorney Ron in the Geragos case, and including the fact that he had been previously sanctioned over $22,000 in that Geragos case, which is exactly what we need to talk about next. We need to take just a moment from talking about this plaintiff's attorney to talk about maybe one thing that he got completely right, and that was that Cardi B's wigs during this trial absolutely killed it. I am also trying to get my hair to kill it, but those are wigs. It's never going to be able to do that. But I do want to make sure that my hair looks the best it can and is as healthy as it can be, especially as I'm aging, because we don't want it getting thin here. In fact, I have some new hair growth, and that is thanks to today's sponsor, OneSkin. You have heard me talk about OneSkin's OS1 proprietary peptide with their skincare, but they also have a new scalp serum, and that is what I've been using on my scalp daily. OneSkin's OS1 Hair is a scalp serum powered by their patented OS1 peptide, and it works by targeting the cells in your hair follicles that contribute to shedding, thinning, and slower hair growth. OS1 Hair can actually reactivate the hair growth cycle to promote thicker, fuller, denser hair. We all want glorious hair. So born from over 10 years of longevity research, OneSkin's OS1 peptide is proven to target the cells that cause the visible signs of aging. So your scalp and your hair stay healthy now and as you age. Go to oneskin.co/hair and use code LawNerd for 15% off your first order. And after you purchase, they'll ask you how you found them. Let them know it's the Emily Show. Now, let's get back to talking about this attorney, shall we? Let's talk about the other case, the Geragos case, the schoolyard glasses stomping ridiculousness. What we have gathered about that case is that there is an underlying attorney malpractice litigation action. That underlying attorney malpractice is attorney Ron with his clients suing Mark Geragos and the Geragos firm. The attorney malpractice stems from a medical malpractice case. So the underlying case was medical malpractice. There was not a favorable outcome for the family of the deceased. They decided to sue their lawyer. Not uncommon. So in trying to sue their lawyer, part of what needs to be proven at trial is if the lawyer would have obtained a different outcome. So when you are doing an attorney malpractice case like that, you almost have to do a trial on the underlying thing. It's fairly complex, and those trials can be long because the jury has to decide almost the medical malpractice case and see all the information in the medical malpractice case, and then look at the attorney malpractice case. And that trial was 2 weeks in when a mistrial was declared after there was a kerfuffle between attorney Ron Rosen and Steve B, because there's numerous Steves involved. And so The court, Judge Mel Redwicana, declared a mistrial and recused himself from the case, so the case went to another court. That was in 2023. So let's look at the appeal with regard to the sanctions of Ron. This case is Hershey versus Geragos and Geragos, August 21st, 2024. Appellants Hershey et al. Appeal from orders imposing monetary sanctions against their counsel, Ron, for discovery violations in their legal malpractice case against respondents Geragos and Geragos and Mark Geragos. Appellants contend the trial court erred in imposing sanctions because they did not file oppositions to respondents' motions to compel discovery responses. We disagree and affirm the orders. Appellants filed a legal malpractice action against respondents, their former attorneys, alleging various acts of professional negligence in handling product liability and medical malpractice claims. When a number of discovery disputes arose, the trial court ordered the matter sent to a discovery referee and appointed a retired superior court judge. Not uncommon. I wish it had happened in some of the other cases we've watched, but the judge said, y'all need a babysitter. Go to the discovery referee. And then the discovery referee, on a more granular level, handles the discovery dispute instead of trying to go back and forth to court. The disputes included discovery responses. In the motions, respondents sought monetary sanctions under the code and attorney's fees and costs incurred to seek the discovery orders. So, hey, you fucked up. We had to spend all this time and money fighting you not doing what you're supposed to do. So not only should you be sanctioned and punished for what you did, go think about it, but also we need you to pay the attorney's fees and cost. All the money we spent trying to get you to do the thing you were obligated to do, pay it back. They go on to say appellants, and appellants is Ron and his clients, respondents is Geragos. Appellants did not file oppositions. Instead, they served supplemental responses. The discovery referee made recommendations on the proper resolution of respondents' motions in 3 reports. She also recommended monetary sanctions be imposed solely on appellant's counsel, Ron. The recommendation was based on findings that Ron misused discovery by making unmeritorious objections, giving evasive responses, violating the court's discovery order, deliberately misrepresenting the date on which the responses were served, and engaging in dilatory conduct designed to delay and impede discovery and trial preparation. Go off. So the discovery referee said this is the conduct that Ron was engaging in. What is happening in that underlying case now? Well, I have an updated minute order from May 2025. I was wondering if Ron was still the attorney of record. Yes, he is. Plaintiff's attorney, Ron. Defendant attorney, Barry Brodowski, and Steve Bellylove. Steve B. May 13th, 2025. Final status conference. The matter is called for hearing. The court announces it's currently engaged in another trial. The courtroom is full. Final status conference is continued to December 2nd, 2025. Department 49, Stanley Mosque. Jury trial is continued to December 8th, 2025, Stanley Mosque. It's going to trial in December of this year. So this case isn't even done yet. The mistrial from 2023 is not done. This case has gotten loosely added to my docket because I'm actually really curious about what's going to happen. But it is starting trial again. I now feel invested because A, Ron's behavior is ridiculous. B, I'm actually curious if there is attorney malpractice. C, I'm curious about what the underlying medical malpractice suit is. This is the kind of case we're probably not going to see other than legal coverage. We're not going to see cameras in the courtroom on this case. That's probably going to be a 3 or 4 week trial. We're going to peek back in probably in the new year after this goes to trial. If the trial gets continued, I will let you know. But it's going to be an extensive trial. It's an interesting thing to follow along with the wildness. And then when I say things like in the Girardi case, in the Murdaugh case, when I talk about how wild it is that all of this had been going on, when you start to see other patterns of attorneys wilding out, I think it's fair to highlight it because we saw it in real time and we saw things happen in the Cardi B case. And I think she handled herself on the stand with incredible composure. But when you see attorneys doing things that you're like, that's taking zealous advocacy beyond, it's curious to kind of go a little bit underneath the tip of that iceberg and see what else is going on. And then there's a fight in the hallway. And you're like, what the fuck is happening? It's wild to watch it unfold. And it's wild to see just the shameless audacity of gaslighting the court, misrepresenting things to the court, and forgetting that zealous advocacy does not negate a duty of candor to the court. Law is not a win at all cost game. And when lawyers treat law like it's win at all costs, it's a huge problem. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.